Good evening, everybody. That was kind of neat. That's something new I was trying with that countdown. Hope you liked it. Make sure to tell me if you can hear me okay. I always want to make sure the audio is working. I know last week we had some problems with Greg's, my guest, his audio. So if you're having trouble with my audio, please let me know. No guest this week. I'm working on somebody for next week, but nobody for this week. So before we got on, I got a bunch of questions. So let me kind of jump right into that and basically try to answer those questions. Let's start with Chris. She applied at age 54 and 8 months, but are now 55. Would they consider the new age at the ALJ level, or should you reapply? Can you explain the grid rule educational levels does not provide and versus does not provide for direct entry? Okay, so first of all, yes, when you are in the middle of your case and your age changes, then Social Security, either at the administrative level or at the ALJ level, will look at your new age. So basically, if you, and this happens sometimes at a hearing, whereas a judge will go ahead and approve a case, but change the onset date to your 55th birthday. And sometimes that's okay. You know, you maybe lose a couple months of past due benefits, but I've had situations where our original onset was, my client was 53. The hearing, she just turned 55 and the judge approved it at 55 and basically cut out 20 months of past due benefits, which was tens of thousands of dollars. The issue there is, do you appeal that? Because obviously if you appeal it, it could be at the state agency level or at the hearing level. Do you appeal that and risk a denial? Sometimes if it's just a few months, I would probably tell you not to appeal it. If it is more than that, if it's $15,000 or $20,000, you got to think carefully about whether you should appeal. So, yeah, but to answer your question, they will change the age, or they will change the evaluation based on your age at the time of decision. And what they do, they would change the onset date to reflect that new age. Generally, it's going to either be age 50 or age 55. But watch out, because if they do that, you could lose out on past due benefits. Now, the grid rule educational levels, what she's asking about is, and let me pull up the grid rules here. Let me just show you an example of one. 1 second here, share screen. Okay, so what we have here is the grid rule. Let me make this a little bit bigger. Oop, I just fall there. Okay, so essentially you've got skilled, semi-skilled, unskilled, none as far as your skill level, and direct entry into skilled work. So let's start with the education levels. No education would be somebody, let's say, who's well, actually, before we get to the education level, let me talk about unskilled, semi-skilled, and skilled, and we'll get to education and transferability. So basically, unskilled work is something that you could walk in off the street and do. There are jobs, and I think there's like 200 jobs out there that exist that you can literally walk in off the street and do them. Maybe being a parking lot attendant might be one of them. There's a number of really simple unskilled jobs, cleaning jobs, janitorial jobs, things like that. Semi-skilled would be a job that you have to have some training, but maybe a month or two of training and you could go right into it. So a lot of jobs are semi-skilled, and then skilled jobs would be something where you might have to have a year of training or education. So it's a lot more difficult to fit in with a skilled job. And sometimes in hearings, if somebody, let's say, worked at a skilled occupation, let's say they're an executive secretary, but only did it for 6 months, then I can argue that should not be considered past relevant work because they weren't there long enough to acquire the skills they needed. So skills are one part of the equation. Education level, you have limited or less, which would be, something, you have basically, some people have no education at all, basically illiterate. That's one level, which obviously is going to limit the types of jobs you could do. Limited or less would be something less than a high school education or a GED. High school grad or more would be, obviously, you graduate high school, have a GED or a college education. And transferability of skills, basically, this is a little more confusing because what Social Security will look at is, have you acquired skills at your job, and do you have the education that would allow you to take skills you've learned from one job and move it into a less demanding job? And so, an example might be, let's say that somebody was an executive, let's say a nurse. And as a nurse, obviously that person would be very familiar with medical procedures and office procedures in a medical office. Well, perhaps that person could be some sort of a technician in a doctor's office or a receptionist in a medical office, where they use their knowledge about medical procedures and practice to do something that's a little bit simpler. It doesn't require as much training or skills or focus and concentration. So really what you're looking at is, can you transfer those skills into something else? In the Social Security world, they use something called the Direct Dictionary of Occupational Titles. Let me show you that real quick. Oops, hit the wrong button here. Excuse me. Present screen. We're going to go to a different screen here. And you can go here to occupationalinfo.org and you can search the DOT. So let's just say, let's look at, let's just say registered nurse. And we'll see what it talks about. So registered nurse, general duty in the DOT is given a code. This here is the code, 075.364-010. It is considered a medium strength job, which means you're lifting 20 pounds frequently, 50 pounds on occasion. And it is an SVP 7, which is a skilled job. And so, a registered nurse or general duty nurse would be a medium level job that is skilled. It's physical as well as it requires skills. That nurse might, let's say, has acquired skills of taking temperature, blood pressure, things like that. They rotate among different clinical services, things like that, prepare sterile equipment. So let's just see medical equipment sterilizer. Let's see what we got there. Okay, sterilizer medical equipment. Okay, this is a light job, so it's less strenuous than the nurse. It's an SVP3, which is a semi-skilled job, a very low-end semi-skilled job. SVP, which stands for specific vocational preparation, would be SVP 1 or that's a gauge of it. SVP 1 or 2 is unskilled. SVP 3 and 4 is semi-skilled. So we have an SVP 3 job that is light. So in theory, a nurse could use his or her skills to become a medical sterilizer. That is it's a less demanding physically job, and it's less requirements in terms of training. So that's an example of transferable skills. I mean, maybe, again, I'm not a vocational expert, but that would be an example of how they would analyze it. So sometimes you have jobs that are so unique to the industry that there are no transferable skills. Auto mechanics is not a whole lot of light jobs that are going to transfer from that. If you're lifting tires and putting engines in and out of cars, there's not a lot of desk jobs you could do, but there's a lot of jobs out there that you could take your skills and transfer. So when you get back to the grid rules, they ask whether you have transferable skills. If you do, then that would work against you being found disabled. And so again, if we go back to the grid rule, and let me go back here, and again, I don't want to spend too much more time on this, but I just want you to see it. Because it's a very good question, and we deal with this all the time. Okay, if you look here at the skills that are transferable, if they are not transferable, if they're unique to the industry, that would work to you being considered disabled. At the sedentary occupational base, again, same sort of thing. Skilled or semi-skilled jobs, and here would be, say, does not provide for direct entry into skilled work. Basically, that sort of skips over semi-skilled jobs, and it's saying, do you have skills that would allow you to go to skilled work? The idea being that most skilled work is going to be less demanding exertionally. So, the transferability of skills analysis is something that a vocational expert would do, but it's simply a way for Social Security to determine whether or not you have acquired skills from past work that would allow you to enter into something else that is relatively close to what you did before. If you have those transferable transferability of skills, it's going to make it more difficult to use or impossible to use the grid rules. You can still argue functional capacity, but the grid rules, big picture, the grid rules are really designed for people who've got physical labor background, who don't have a lot of skills, and those skills really don't transfer into something lighter. And the way I always like to put it is a construction worker who has a bad back, there's not a lot of things that person can do, and that's what the grid rule is all about. So I know it's a little confusing, but essentially transferability of skills is looking at the skills you might have obtained. So that is big picture. But take a look at the grid rules, and you can see kind of how that works. And I give some examples in my website, gridrules.net, of how the grid rules would be applied. Okay. Elizabeth says, do you think it's worth appealing a judge's decision about your back pay? I mentioned this a second ago. I think that if a judge awards you benefits but changes the onset date by many, many months, then the issue you run into is, do you agree to that change and forego all those past due benefits? I think if it's a few $1,000s, I probably wouldn't appeal it. If it's $20,000 or $30,000, you got to think long and hard about it. Also, how are the merits of your case? Do you have a really strong case? I've got several that I've appealed because we lost our past due benefits. I felt like, and my client agreed, the risk was not that great because the person was found disabled, realized by a judge or by a state agency. So obviously there was something going on there. So really the worst case in most situations would be that the judge would simply say, yes, I'm finding you disabled, but I'm sort of affirming the state agency decision. Now you could draw a very, very low approval judge and all bets are off. But I think, depending on the money, you have to make a decision. All right, Christina, I think you've been here before. Hello from California. I hope things are going well. I hope it's not too hot out there. Emily says, what are your thoughts about expedited reinstatement? What Emily's talking about is a system where if you are approved and then you go back to work, I think it's 30 months, and I don't really deal with this very much, that you can say, okay, my disability has resumed, and you generally call the local office and say, I want to be processed for expedited reinstatement. I'm not working anymore, and they will go ahead and put you back on benefits. So, again, this is just a situation. This is a process where, if you've been off benefits, and really it's big picture here, Social Security wants to get people to back to work. And so if you try to go back to work, you've got the trial work period of up to 9 months in any 5-year period of time. Then you've got the expedited period of disability where you can go back on disability within 2.5 years if things don't work out. So it's designed to encourage people to go back to work. I've never really dealt with an expedited reinstatement problem, so I really am not the right person to ask about that. I know Greg Brinkley talked about that last week, I believe, and you can certainly email him if you'd like, Greg at gregbrinkley.org, I think, to find out a little bit more about that. But I don't know much more about it than that because I just don't deal with that. Okay. Do I lose my SSI if I move to another state? No, you do not. SSI and SSDI are both federal programs, so it doesn't matter where you live. Now, if you move to a different country, could be a different story, but not to a different state. Okay, James, my hearing's in a few weeks. I'm 46 years old, was injured on the job in 2021, had a disectomy, did not get any better, had a spinal fusion June 12th of 23, and I've continued to decline. I use a walker and constantly fall. My neurosurgeon says I've crushed another disc and will need another surgery. I am currently waiting approval from workers' comp, seeing a psychologist. Okay, so James obviously has a very significant medical problem here. I think you probably will win, or you've got a real good chance of winning. The issue you run into is if you're getting workers' comp benefits, those benefits offset Social Security. So you may win, but when they start to do the money, they look at the workers' comp you're getting, and they'll say, well, you're getting workers' comp, you can't collect both. So until you settle your comp case, there's no Social Security. Once the comp case settles, then you'll start getting your Social Security. And when you settle it, you want to make sure you have language in that settlement that basically says that this money represents a payout. The workers' comp settlement represents a payout over your expected lifespan, so it doesn't offset your Social Security for the next 5 or 6 years. It might knock it down by $10 or $20 or $30 per month, but not a whole lot more than that. But you can't really do much with Social Security. You can't win benefits. You can win your case, but you're not going to see any money as long as you have an active workers' compensation case. And in fact, Social Security will ask to see the workers' compensation documents. But I think you are 46, which hurts a little bit, but I think you've got significant enough medical problems that absent, a workers' comp situation here, this would be a case that I would say is pretty viable, but the workers' comp would offset any kind of benefits. Big One says, hi everyone, and do not forget to press the like button. Thank you, Big One. And yes, please press the like button. And if you do find this helpful, please leave me a nice review. Let me see, I've got a link there. Yep. So please leave me a nice review. I got several from the last few weeks, which I really appreciate. Really helps me grow my practice because, all the Google and other search engines, they look at reviews. That's the way, people vote for businesses and lawyers and restaurants and all that stuff that they like. So a favorable review, and actually more than just, I've got a number of them that just have 5 stars, which I appreciate, but it'd be better to say, the things that Jonathan talked about in his live stream or in his videos were very helpful to me. So put a few words in there, not just the 5-star. Hopefully it's a 5-star. Okay. Let's see here. I said before I went on, I said I'm about to go on, and Boster said bring donuts. And actually, Boster, tomorrow happens to be on my birthday. I'm not going to tell you how old I am. You can guess. But, if you are going to send me donuts, powdered donuts, I kind of like. So, although the trouble with donuts, I don't know if you guys find this or not. The first 2 bites are really, really good. Then after that, it's just kind of downhill. So I really like the first 2 bites of a donut. Of course, I never stop. But, if I had self-control and I was to stop, the first 2 bites are the best part. And then it kind of goes downhill, at least for me. Okay, enough about donuts. Art of practice. Hello. After an ALJ denial, under what circumstances, if any, can an SSDI claimant file a new claim while the current claim is pending? If the appeals counsel, you cannot. They used to let you do that. Now, while you're at appeals counsel, you cannot file a new claim. When you go to federal court, if you go to federal court, you can. But basically, you've got to choose either to start over or to file an appeals counsel appeal. And while you're at the appeals counsel, you cannot file a new claim. Donna Clark says, good evening, Donna. Okay. Everybody says you can hear me fine. That's good. Okay. Love the countdown. Okay. That was kind of cool. Like I said, it's, I use this program called StreamYard. I've got a couple of different ways to do live streams, and the StreamYard is web-based, and it's got these things built into it, and I'm just kind of still learning it, but I thought that countdown was kind of cool too. My friend Rodney is here. Rodney has been a loyal viewer every single week I've done this, which I really appreciate. Rodney, good to see you again. I was looking at your file, by the way, and we represented you. Someone in my office represented you. You had a really tough judge, and you won. And so Susan, who I think did your case, did a really good job, because you had one of the more difficult judges. So I'm glad that you won, because it was an uphill battle with that guy. Blue MD. My first appeal has been since December 4th, 2023. I'm assuming he's talking about or she is talking about the reconsideration appeal, recon appeal. So you file your application for benefits. It may take 8 or 9 months. You get denied, you file a recon appeal, reconsideration appeal. It could be another 8 or 9 months. It could be longer. There are places in the country, and I do cases all over the country, as you probably know. It can be a year and a half. Social Security doesn't have enough people. In certain places, they're so backlogged and so deficient in staff that they've got their staff people that should be adjudicating cases, answering the phone or doing replacement Social Security cards or processing retirement claims. So unfortunately, there's nothing much you can really do. The only thing that seems to work would be to contact your elected representative, your senator or U.S. representative, and ask for what is called a congressional inquiry. I think that once you get beyond 5 or 6 months, that would be appropriate. I wouldn't do it right away, but I think after 5 or 6 months, it would be appropriate. Okay. Well, I get my back pay at once. just got approved. For SSDI, you do. For SSI, you do not. SSI, they break it into 3 payments, I think 9 months apart. I cannot tell you, there's no reason why, other than because SSI is a means-tested program, and I guess they figured that if they gave you a lump sum of $15,000 or $20,000, that would make put your asset picture beyond what is allowed for SSI. So I think that that's probably what the rationale is. All they have to do, of course, would be to change the law that says that money received from SSI as a lump sum shouldn't count against you. But they pay you, but they make you suffer. So SSI only is broken into 3. SSDI is lump sum, all at the same time. All right, Rick says, I had my phone hearing with the judge in February. I've not gotten a decision yet. Should I be worried it's going on 5 months? No, because some of these cases can drag on. 5 months is starting to be a little bit much. I mean, I'm getting decisions, like I just got one today. We're in July, from a case I tried in April. It was approved. It was actually a case I'm a little surprised we won. I was real happy to see it because it was a tough judge. But, it can be 4 or 5 months. It just depends on how busy the hearing office is and how busy the judge is. But, I think that I would say that, 5 months, you might ask your attorney to reach out to the judge's office just to find out what's going on, make sure nothing slipped through the cracks. That is a little bit long, but not unusually long. You get beyond 7, 8 months, that's starting to get to be really, really too long. Yes. Hi, Jonathan. I'm in Orlando, currently receiving SSI, waiting a decision for SSDI on the Ticket to Work program. 60% has been processed. So I'm guessing what's happened here, ES, is that you generated, while you're on the Ticket to Work, you generated enough credits to allow you to qualify for SSDI. I would think that because you qualify for SSI, that it's going to be a little bit easier, simply because you've already been found disabled. So I suspect they're going to look at the new medical to see, has your condition improved? But obviously you're older now as well. So, I think in general, the fact that you've tried to go back to work under Ticket to Work, you're older, and you were previously found disabled, that's all very positive. But again, and by the way, the 60%, as Greg mentioned last week, is just, it's garbage. There's no way they can know. It's just a way to kind of keep people calm. So don't buy that at all. It could be, 2 weeks, you could get a decision. It could be 6 months. There's no way to say. Okay, my voice is wonky. Okay, well, I've got my microphone right here. Let me move it a little bit higher. Shouldn't be wonky, but again, this is, I'm testing some different microphones, but this is the one I have been using the last few weeks. It seemed to work okay. Okay, but let me know if voice isn't tracking. Yeah, and that's a problem because, and this is a big problem with live streaming in general, and that is that the video and the audio aren't always going to line up because they're 2 separate channels, as it were. There is another technology that I've used called a YOLO box, which allows me to make those offset changes to make them match up. The problem with YOLO box, it doesn't have the same functionality as StreamYard. So I will keep looking to see if there's a way to, line it up a little bit better. So I realize it's not ideal, but just bear with me. There's nothing I can really do about it. Okay, Marina. I am 58 years old. My hearing's next month. I don't know what to expect from me. I do go to all medical appointments. I do take medication. I'm unable to work. Well, Marina, you don't say what your medical issue is, but certainly it helps. You're 58. If you have not already done so, look at the grid rules. Go to gridrules.net. If you have a physical limitation, see if they apply. So the grid rules can really help you. You can be disabled even if you are able to do light work. Light work being standing and walking 6 out of 8 hours, lifting 10 pounds frequently, 20 pounds on occasion. So that's a lot of jobs. So I think that works in your favor. If it's mental health, even though the grids don't apply, I still think that Social Security recognizes that people over 50 and over 55 in particular are going to have a really difficult time getting back into the workforce. So hopefully that will be the case for you. Okay, the voice, I know it's not, and again, there's nothing I see in StreamYard that allows me to fix that. I will look and look at the FAQs, and if I can't fix it, I'll try something else, because I agree. It's disconcerting when you're watching somebody talk and the voice and the video aren't lining up. Okay. When a medical opinion gets overruled by another medical expert, I think it's, let's see, I'm not sure what you're saying. Yeah, I think what you're getting at is that if the judge has two competing medical opinions, let's say one says that you have severe limitations and you're limited to, you have to take 3 unscheduled breaks during the day and you can only sit for 15 minutes at a time, stand for 15 minutes at a time, and you have debilitating pain. And the other one, which is a consultative evaluation from a one-time visit with one of their doctors that says you have mild impairments. So opinion one is from a treating doctor that you've been treating with for the past 5 years, who knows you, who's been dealing with you and tried a bunch of different procedures, medications that don't work, and then the other is a one-time visit. Well, Social Security in its wisdom has decided that a judge can take the one-time visit and decide that's the more accurate one. It makes zero sense to me. This is there used to be something called a treating source rule, which basically said that a treating source, a long-time treating source, like a doctor who has seen you for 5 years, that would be given much more weight over a one-time visit. But they got rid of that because of the Eric Kahn debacle. There was a case involving fraud. And so they got rid of the treating source rule. There's been a push to try to get it back in some form, which would be nice. I will tell you, most judges aren't going to take the opinion of a one-time consultative doctor over the opinion of someone who's known you for 3 or 4 years, but they can. Judges also can, or Social Security at the administrative level can decide that one opinion is more compelling than the other. A lot of times they'll look at the underlying medical records, and I've seen this happen where the underlying medical record describes kind of a mild impairment, whereas the opinion statement, the medical source statement or functional capacity form describes something as severe, and the judge says, well, the underlying medical record is not consistent with what this was said on the form. And they can disregard the form on that basis. So, I think it's always important to, look, it's always better to have a treating doctor that you've treated with for a long time. Always better to have a specialist if at all possible. And if you do get a form from a doctor, a functional capacity or medical source statement, look at your medical records. Your attorney, you look at the medical records. Is what's said in the medical record consistent with what is on the form? And if it's not, you might want to go back to the doctor and say, you need to resolve this inconsistency. Okay, Blue. First appeal, let's see. Okay, so the first appeal, which is the Recon appeal, December 4th of 23, got a lawyer after doing it yourself. Probably makes sense. You've been denied once. Recon, you're not going to get approved, quite frankly. It's a rubber stamp for the most part. Total body assessments at National Institute of Health, good move. That's a very reputable and credible source. It will definitely help. What your lawyer will help you do is, number one, make sure that all those records are in the file. Number two is help you with the forms they're going to send you. Review them. What I do is, like, for example, my client gets a adult function report. I'll say, fill it out, send it to me, and I'll review it and make suggested changes for you. I'll file it electronically. If mail comes in, I'll remind you, you've got this consultative evaluation to go to. If there's a problem, such as I had a case one time where my client had a terrible back and the consultative evaluation was 100 miles away. I got on the phone, talked to the adjudicator. Look, my client can't go 100 miles. That's an hour and a half, 2-hour drive. She's got a really bad back. Let's find somebody else. Things like that. I will reach out to adjudicators if I think my client has a case that should be approved quickly. Sometimes they'll do that. Honestly, though, at the Recon level, it's more of a monitoring function to make sure things are happening, looking at your file, what's going on, making sure the record's updated. Your lawyer is going to earn his or her money at the hearing level. So it's not a mistake to get somebody at Recon. It's probably not going to get approved anyway. Very few are approved. So having a body to look at, another pair of eyes, not a bad thing. But your lawyer is going to make his or her money at the hearing level. That's when really we do most of our work, in all honesty. Okay, John. I'm 63 during retirement, applied for SSDI and denied. that said that you had limitations, could do previous work. Yeah, the grid rules would apply in recon, absolutely. Now realize that you have a skilled job, so the question is transferability of skills. Now I will tell you there's something out there called the POMS, P-O-M-S, and let me pull it up for you, which is a program operations manual that Social Security has. And let me see if I can find it real quick here. Here we go. Let me share my screen so you can see. And what the POMS does is it talks about transferability of skills. If you go down here to section section D, what it basically says is that if you are limited to, you're 60 years older and you have a high school graduate or more, which John does, and the skills are not transferable, then you're disabled. What the POMS says here is that at age 60, if you're limited to even light work, Social Security can require very little, if any, vocational adjustment. And that means that basically you've got to be able, they have to prove, not you, they've got to prove you could go back to your past work. So logically, if you stopped working because of a problem, whether it's physical or mental, and the evidence is supportive of that, it's not going to make a lot of sense that they're going to then decide later on, oh, you could go back to your past job. There's a reason you left that job. So at 63, you have a real advantage because you could be limited to light work, and you have that little vocational adjustment standard that applies here, makes the grids a lot more applicable to you. Now, we'll tell you that if you're getting disability, if you're getting retirement, then what you would get if you win disability is the difference between the retirement and early retirement and full retirement, or SSDI. That may be $400 or $500 a month. That's why it can be hard to get a lawyer, because if I'm going to take a case and the past due benefits that I'm getting paid on is $500 a month or $400 a month, and let's say you get approved in a year, so maybe there would be $5,000 or $6,000 of past due benefits. That means that the attorney's fee is going to be $1,500, which again, I'm not scoffing at it, but most cases, the fee is going to be $4,000 or $5,000. So, taking a case in the same amount of work and you're getting paid $1,000, $1,500, $500, not really worth it. I had one case, as a matter of fact, where my client had applied for early retirement, took the case. My fee was, I think it was literally $63. So, I did, 2 years of work, tried a case, and I got a whopping $63. Again, I'm glad for my client. We won. She left me a nice review, which I was appreciative of. But clearly, I can't stay in business where I'm getting paid $60 on a case. So, you may find if you're getting retirement that it might make more sense to try to do it on your own, because it could be hard to find a lawyer to do it. But, some lawyers will take it, but that's just my experience. Okay, let's go back here. We have guilty traveler. Okay, my information and guidance was invaluable in gaining approval above and beyond others. Thank you. Well, I appreciate that. I'm glad, I've said this before that, I do this because, first of all, I think it's a good karma thing. I think that, putting good information out, helping people understand this very, very confusing process, it's the right thing to do. I think, again, you put good stuff out in the world, it comes back. But there are plenty of cases. I have plenty of work to do. Most of my colleagues have plenty of work to do. And if you can do this on your own, and you can learn from my videos, from other videos, and you can do it on your own, more power to you. Again, there is a place for lawyers. Some people don't want to deal with the hassle of it at the initial and recon. I've taken those cases. Certainly at a hearing, I'd be hesitant to do a hearing on my own. But, at the initial and recon, if you can deal with all the paper, then by all means do it. But I'm glad that this forum, as well as the videos and other materials I've got, were helpful to you. And again, all I ask is just a nice review if you have time. Okay, Draco says, my case has been at DDS, and that stands for Disability Determination Services, for over a year. Got a call today saying my release has expired. Good sign, bad sign, or just common? What he is getting at is The release is called the Form 827. This is a medical authorization that Social Security asks you to sign, and basically it allows them to get your medical records. So, if your release is expired, that simply means that obviously the case has been sitting for way too long, and you sign another release. It doesn't mean anything as far as the merits of your case. It just means that you got to sign a new release. But I would tell you, if it's been at DDS for a year, this is a situation where it might make sense to reach out to your elected representative and say, make a phone call for me, write a letter for me, do the congressional inquiry. That's way too long. But it doesn't. It's uncommon that cases are out there that long, but it's not uncommon to get a new release or to be asked for a new release. Okay. Blue was diagnosed in 2020. Doctor says it looks 13 years advanced. Again, I'm not sure, Blue, if you told me what the underlying medical problem is. I know you're the one who just got a lawyer. I think that onset is, let me talk about that a little bit, because people sometimes say to me, well, my disability really began 15 years ago. But if you worked, you're not disabled. So, you got to look at a few things. Number one is, when did your condition get to the point where it stopped you from working either a full-time job or working at a level where you're earning $1,550 a month or whatever the number was for substantial gainful activity in the years past? It could be 1,510 or 1,470, in that neighborhood, $1,300, $1,400, $1,500. So, when you stop working, that could be your onset. Second is, realize you can only get paid 1 year prior to the date of your application. And if you add the 5-month waiting period, you're looking at 17 months. So if you allege an onset date, more than 17 or 8, let's use 18 because partial months don't count for the 5-month waiting period. You allege an onset date more than 18 months prior to your date of application, it's not going to change how much money you get. So I think that when you're looking at your application, doing an application, choosing an onset date, choose one that reflects when your medical condition deteriorated to the point where you could not work and that you were not working, but realize anything more than 18 months is just, it's wasted. So, I think it's important. My experience has been that many judges really look for some sort of a connection between something in the medical record and your onset date. So maybe a date of a surgery or the date of a fall. It could be just a made-up date, but like I said, it's usually better to have something that directly relates to it. So, you're diagnosed in 2020. I'm assuming that you applied in 2022 or 23. So, you could still use a 2020 onset date, but your lawyer might tell you, and this is something else a lawyer might tell you, is you might want to change that to make the judge's life easier, because it's easier to find somebody disabled later on. And if it doesn't make any difference to you monetarily wise, then why not? Go for it. Let's see. All right, John, he's a gentleman who's 63, who's getting retirement, Social Security, got a decision. They didn't look at medical submitted. And this happens sometimes because what happens is the adjudicators will gather the medical evidence. They'll send it to one of their in-house doctors to make a call on it. And I suspect they probably have an internal process that says, after such and such a date, I'm not going to look at anything new, because if they get something new, they got to reopen the whole thing, and they're under pressure to process cases. So it doesn't surprise me that a state agency adjudicator would sort of use a cutoff date, maybe the date that they sent the paperwork electronically over to one of the in-house doctors, and anything that came in afterwards, they're just not going to consider. They shouldn't do it, but I think they do, because they had the pressure to get these cases along. So I think that it's possible that those records were not considered just because your case was getting so close to a decision, but it would be considered in the next round. Eric 14, may I call you? I'd rather you send me a copy of your denial notice. I find that it's a lot easier for me to review. If you've got a denial, hearing denial, happy to look at it, send it to SSD Answers 123 at Gmail. Happy to look at it, but I can kind of tell sometimes whether there's something that I could do with it. And, obviously you are, for obvious, logical, reasonable reasons, believe that you are disabled. But what I'm concerned about, if we're looking at an appeal, is what the judge's logic was and what the evidence suggests. I looked at an unfavorable decision today, for example, and the reason it was denied was that there was no objective evidence. The claimant, the person who was asking me to review it, was alleging disability based on back pain. No MRI, no CT, there was some old x-rays. There was just nothing there. And the judge is like, and they have this language, that the claimant's, allegations of impairment, are partially acceptable or partially acknowledged, but not to the degree that they're alleging. Something, I forget the language, that's kind of what they use. So that case, there was really nothing I could do because there was no objective evidence. So if you want me to look at your denial, happy to do it. But again, email it to me at SSDanswers123. I need it in one PDF, not, sometimes people will send me 30 JPEGs. They've taken a photo and it's 30 JPEGs and it takes forever to kind of print that out and put it together. So I really need it in a PDF format as one document, all the pages in order, right side up and all that. So, but I'm happy to look at it if you would like. Okay. I'm appealing an unfavorable decision, got diagnosed with breast cancer. Should I withdraw my appeal and start over again? It depends on when you were, I always say this, if you can appeal, that's probably a better option than starting over again because you're going to give up a lot of past due benefits. Now, if the breast cancer diagnosis was recent, after the time or right around the time of your hearing, and you've got symptoms that arise from it, and the underlying case before that was kind of weak, then maybe it does make sense. But again, this, if you want me to look at your decision, let's see what it has to say. And of course, breast cancer grade 3, you don't win on a diagnosis. You win because of the underlying condition, pain or limitation of movement or something like that, or medication side effects. So if you're undergoing radiation and chemo, that might keep you out of work. So that could be a reason to ask for start a new application over. But again, those are some of the decisions that you really got to look at, kind of as a whole. All right. Okay. When you were approved at 55 and a half, a guilty traveler's one, I think said some nice things about me. So appreciate that. The approval said to be reviewed in more than 5 years. That basically means they're not going to review you. I had an interesting meeting with a client of mine the other day, about a week or 10 days ago, and he had gotten he's a real bright guy. He had gotten a continuing disability review form, the short form, and there's a code on there that had all these numbers and letters, and he figured out the code. And he showed me that, certain codes in the CDRs say this is a case not likely to show medical improvement. This is a person at a certain age level. So it kind of backed up what I've been saying all along on these live streams, is that when you're over 55, the odds of being reviewed are very, very slim. And if they do review you, they're going to get the short form, and you're probably not going to be moved. They're probably not going to be moved for termination. So I think guilty, by and large, you're safe. I don't think there's going to be a problem there. Calvin, I checked my Social Security website. My application is 88% at DDS. When it reaches 100%, should be expecting a decision. Calvin, as I mentioned before, those percentages mean nothing. So, you just can't assume anything. I mean, it's better than being, 20%. It's better to be, but 88%, how do they know? I mean, how do you figure out if by law decisions had to be made in 240 days, let's just say, 200 days. Okay. You could figure out, 88% of 200 is whatever number that might be. So you could figure it out, but there's no specific amount of time that a case could take. It could be 3 months, 5 months, 8 months, 12 months, 15 months. It just depends. There's no way that 88% means anything. It's just a made up number to try to keep you from calling them. But again, better than being nothing, but you could still be waiting, 3 weeks or 3 months or 6 months. So again, you should be expecting a decision, hopefully next 3 or 4 months, but don't put any weight into the 88%. Okay, good question, Aaron. Thank you for your contact. You're very welcome. What happens if 5 years go by, you don't use all 9 of your trial work period? It resets. The trial work period is a rolling 5-year period of time. So in other words, let's say that you get approved and then 2 months after your approval, you go to work and you go over the trial work period amount, which I think is $1,110. Okay. And then, for the next 60 months, that 1 month will count in that time period. But once you hit 61 months, that first month drops off. So it's a continuous 5-year period of time that keeps rolling. So if you front loaded your work attempts and you're over trial work period months, let's say the first year after you became disabled, or even before you became disabled, use trial work period months, which is a different story, but you can do that. Then once you have rolled out of that 5-year period of time, then you start a whole new trial work period, and you've got 9 more trial work period months. So it renews. It's not a one-time thing. It's a rolling 5-year period of time, which is kind of nice. Although 5 years is too long, in my opinion. It should be shorter before it rolls off, but nobody's asking me. Okay, Jerry says, disability call being certified employees. If they didn't ask if I'd done invoices, I don't have. Cervical self-employed tow truck driver. Okay, so what I think Jerry might be getting at is, he may have a business that is generating money that is being associated in some way, shape, or form with his Social Security number. So they're seeing ongoing earnings. But Jerry may have told them that, in fact, he is not operating a tow truck. He has employees doing that. So if they see earnings go to your Social Security number that are substantial, again, close to or over the substantial gainful activity, they're going to send you a form and ask you to explain that work. And if you have employees, then that could be the explanation. My employees or my spouse, they're doing it, but you may have to get evidence of that, affidavits, sworn statements, things like that, tax returns, to show that, in fact, you are not doing the work. I had a client we got approved who owned a restaurant. And he still owns the restaurant, but he's not, he doesn't work in the restaurant. He just owns it. And, he's not doing anything on a regular basis to further the business of the restaurant. So in that situation, we got evidence to show that he was not working in the restaurant, and therefore the earnings he got did not count against him as substantial gainful activity. And Jerry's 54. So again, same thing. It's just really about, are your employees doing the work? I think Christina is from California, or maybe Vegas. I saw Vegas had like 10 or 20 days of 115 degrees in a row, which is absolutely nuts. I have been in that level of heat, and it is brutal. And I know some places in India are like 130. It's really crazy. But I've been in that. I've been in Arizona one time when it was 110. I'm in Atlanta. It doesn't get that hot in Atlanta. I've been overseas where it's gotten that hot. I was in Israel one time. I was over 110. It can be really, really, difficult. It's dangerous, obviously. And if you don't have air conditioning, all these folks in Texas with that hurricane that came through, Hurricane Beryl, they don't have air conditioning, and it's humid and it's hot. That can be life-threatening. So I feel your pain. I mean, today here in Atlanta, it was like 88 or 89, which is, pretty reasonable. I mean, we've been having a lot of 94, 95 days. And, it's not that humid, but, thank goodness for air conditioning, because, wow, it is, that's pretty brutal. And just stay safe, because that's really, really hot. Okay. How much money can you make? Classy Keys asks. And that would be before taxes or after taxes. It is gross income. So if you're on SSD, and I've explained this before, it's a little confusing. You have different tables that apply. The trial work period is up to 9 months in any rolling 5-year period of time. You can earn $10,000 a month. Doesn't affect you. So you can work up to 9 months in any 5-year period of time. Won't affect you at all. Once you use up your trial work period months, the 9 months of trial work period, if you go over SGA, and SGA is substantial gainful activity, for 2024 it is $1,550. For 2023 it was $1,510, I think. It'll be $1,580 or $1,600 in 2025, some different number, changes every year. You can look it up, just Google substantial gainful activity. if you are earning less than SGA, then that is not going to be a problem generally. Now, Greg and I talked about this last week. Brinkley and I talked about it last week. He's of the opinion that if you're earning less than SGA, you could be earning right up to that limit. You could be earning, if again 24 is 1550, you could be earning 1549 month after month after month. It will not affect you. I disagree with that. I think that if you're earning really close to SGA, that is going to trigger somebody to ask, are you suppressing your income? And that could trigger a review. Realize Social Security has to strike a balance. On one hand, they want to encourage people to go back to work. And the trial work period, the ticket to work, all these things, and the SGA, they want to make sure people try to go back to work. On the other hand, they don't want people gaming the system. But if word gets out that, by trying to work, that's going to trigger a review or a termination, you're going to have fewer people trying to go back to work. They don't have many people going back to work anyway. So, they want to keep that as much as they can. So I would tell you that, if you are working on a regular basis part-time and you've used up your trial work period months, I would say, keep your earnings in the $1,300, $1,400 range. I wouldn't go to the 1,500 plus, because I think that could be asking for trouble. Greg Brinkley disagrees. He says it doesn't matter. He used to work for Social Security. I didn't. So take that for whatever it's worth. You can write reviews with chat. Okay. Well, so I talked about the reviews, and Blue MD says you can write reviews with Chat GPT. Yes, you can. It's interesting you mentioned Chat GPT because there's a lot of companies that service lawyers. Like any industry, there's a lot of companies out there that are trying to sell products to lawyers and services. And so, some of these artificial intelligence bots, Chat GPT and things like that, are coming into the legal space. And, I went to a convention. I've been to a couple of conventions for disability lawyers, and there's several of them that offer the AI medical record analysis, where you dump a medical record file, the PDF, into the AI engine, and it gives you a summary. And, that obviously the privacy concerns, and most of them have, privacy releases and so forth. But the point is, I've tried a couple of these, and I've not found one yet that I really like. Because it doesn't qualify stuff. In other words, it looks at a record, and the example I can give you is I had a client who had some significant back issues, but also had a foot injury, and the foot injury was recent, and it required a couple of surgeries. It was probably not disabling, but it was a lot of in the record. Well, when I got the AI record, or I guess the summary back, it focused a lot on the foot injury because that was recent and it was a lot of volume. So it looked and said, okay, of the 1,000 pages of medical records, 300 are about the foot injury. It did not know that the foot injury was not really that significant when it comes to disability, because you can do certain jobs sitting down and so forth. And, didn't completely prevent her from walking. So at this point, Chat GPT, which is not, I don't think, does not meet the privacy requirements of HIPAA, which I would use it for a client, but it's not perfect. And I think for reviews, you could put something in there and ask it to write a review. That's probably sufficient purpose for that. But I know people, a couple of people I follow that are using, Chat GPT to write ads for Facebook ads, or to write questionnaires for their clients. So it's a big deal, and I think it's coming. But you've heard the expression "garbage in, garbage out." I still think that applies, and there's until the Chat GPT or something like that can replace what's in here, then it's not going to really concern me too much, because I just don't think that a machine is going to be able to really replace 30 years of experience. That's just my experience. Now, I will tell you though that what it could do is, I expect to see some AI engines that look at your profile. I'm 47 years old. I've got a herniated disc at L4, L5. I've got a bulging disc at L5, S1. I've got I'm diabetic, and you put all those in there, and it can run through various scenarios and say you've got a 63% chance of winning, or you've got a 49% chance of winning, or an 87% chance of winning. That I could see being valuable to people. Because again, it doesn't say for certain, because you get a judge that's, out to lunch, or a judge that's a real high approval rate, you may still win or may still lose. But I think it could help people get a better sense of the viability of their cases. So, okay. Ben Adams, 25 again. I'm not sure what Ben is getting at. 20. Oh, my birthday. Yeah, that's right. 25 again. Yeah, I don't think that's quite there, but you know what? I don't know if I would really want to be 25 again. I think I've learned a lot of stuff over the years, and I was thinking about this the other day. There's something, you get better at what you do over time. And obviously, you can't do as much stuff physically. I play tennis a lot, and I can't move the way I used to move. Although, again, speed was never my thing, so it's not as bad of a problem as maybe it could be. But you know what? It is what it is. We only move forward in one way. So I think what you got to do, and this really applies to disability, you can't change if you have a congenital heart problem. You can't change a herniated disc. You can get treatment for it and so forth, but you're never going to be, as healthy as you were 20, 25 years ago. It just is. So rather than fret about it, just got to move forward. But I appreciate the birthday wishes anyway. And hopefully someone in my family will remember that there's a certain Rhodes Bakery cake that I really like. So just happen if anybody's tuning in, Jake or Jess, if you're tuning in, Rhodes cake would be nice. Anyway, okay. Is this happening, Emily says, on July 10th? Today's July 10th. Yes, this is live and in person. It is July 10th. And my birthday is tomorrow, July 11th. Okay, get yourself a steak. You know what? I'm not a big steak eater. Every once in a while, maybe once a year, I'll have a steak. Just not, it's heavy. I really have gotten to be, as I've gotten older, I like fish much more than steak. I'll eat chicken, let's say Chinese restaurant chicken, or my wife makes a really good chicken dish. I'll eat hamburgers occasionally, but I'm really more of a fish person. A good, grouper or snapper or trout I really like. Salmon, of course, we eat a lot of that. I just find it's easier to digest, and I just, like it more. Steak's fine, but I'm just, not a big steak eater. In fact, I was at this convention in Nashville a few weeks ago. In fact, that was my first live stream. And there was a raffle for a dinner at the Capitol Grill, which is a really nice restaurant, steakhouse. And I won the raffle, which is kind of cool. And so I got a gift certificate to this Capitol Grill. So I'm taking the whole family. We're out on Saturday night. We're going out to the Capitol Grill for dinner, and I'm looking at the menu, and it's like steak. Like, I'm just going to get a nice piece of fish, maybe a baked potato, and a nice dessert. I'm cool. I don't need a steak, but I understand people really like them, but I'm just not a big steak eater. Once a year, yeah, it's kind of good, but just not too much. Okay. Justin says, I talked to the DDS examiner. That's smart. I think it's good if you can establish communication. They didn't get a capacity report, but got a work history. What's going on in mail both at the same time. Okay. So what Justin is talking about here is he submitted some documents and they didn't make it to the Social Security file. Imagine that. This is, somebody asked before, what is an attorney going to do? This is one of the things we can do, is because we'll have electronic access to your folder. So when I submit a document, I go into the ERE system and I submit it electronically. So it's going in there. If you do it yourself, you've got to use something called a barcode. And the barcode is something they're supposed to give you that associates your file with that piece of evidence. And every piece of evidence has got to have a separate barcode. So if you have a capacity report and you've got a work history, that's two separate submissions. It's very possible that you put it under one barcode and it basically got, just misfiled, or it got lost, if you did it by fax. So, it's not unheard of, believe it or not, to submit things 3, 4, or 5 times before they get it, unless you're doing it electronically. And, again, I was stating the facts. This is what one thing an attorney can bring to the parties. Stuff doesn't get lost because A, we are submitting electronically, and B, we can generate a printout of what they've received. If it's something that we submitted that's not there, I can see it right away. And sometimes, by the way, it'll be put into the wrong part of the file, and you got to track it down. But, I would tell you just file it again, resend it again. and definitely make sure you have a separate barcode for each piece of evidence you submit. Okay. I know I'm out of sync here. That's just because of the technology here. But I appreciate the birthday wishes. Okay. What is the offset? It's generally going to be 100%. There's a formula there, but I think in general, unless your workers' comp rate or TTD benefit, temporary total benefit, is very, very low, the offset is going to be a 100% offset. So you won't see any Social Security while that comp case is still active. Melinda, 58. I wanted to know, I have to quit my full-time job and apply for disability. Yeah, because Social Security, they use something called a 5-step sequential evaluation process. And it basically says that the first question is, are you working? Are you working at SGA level or more? So if you're working and earning more than $1,550, they stop the inquiry. You are not disabled by definition. Since disability is defined as the inability to work, if you are working, then by definition, you are unfortunately not able to pursue a disability case. When you stop working, I would never tell you to quit your job, by the way. I would tell you to hang on as long as you can, but if you have to stop, then you could apply. What has been my experience with schizophrenia cases? Mixed bag. I will tell you that, what judges expect to see is a person who has a really difficult time taking care of basic needs, feeding himself, herself, dressing, paying bills. I had a case a number of years ago with a client who medically I thought had a severe case of schizophrenia, but was living on his own in an apartment a block away from his family. And he was paying the bills and he was paying his rent and his family wasn't really helping him. So he had minimal capacity. He couldn't really do a lot else. He had difficulty, he would eat breakfast at 11 o'clock at night and he would, roam the streets and he'd play video games, but he could take care of his basic needs. He'd get dressed. He would bathe every couple of days. He was getting his bills paid. The judge is like, he's able to function in that regard. I think he could probably do an entry-level job. Harsh? Yeah, a little harsh. That's probably not, I don't think that's a logical conclusion. This is a judge out of Texas. Texas is known to be a little more difficult. So, normally what I look for in a schizophrenia case is, typically hallucinations, audio, visual hallucinations where a person can't really distinguish what is real, what's not real, difficulty managing, daily activities like taking medications, getting dressed, bathing, needs to be reminded, needs help with all that stuff, needs help with public transportation, can't do a lot, basically has a difficult time meeting basic needs because of difficulty, understanding reality and non-reality, it has emotional outbursts, just illogical actions. It's just got to be at a level where functioning reliably at a job would just not be possible. It helps a lot if you have a treating psychiatrist who will agree and go on record with the functional capacity form. It helps if you have multiple failed medication trials. Drug works for a while, then it stops working, you try a new drug. It helps to have inpatient hospitalizations. Sometimes you see drug and alcohol use because of the underlying condition, and you got to unwind that sometimes, and you got to show that the schizophrenia exists independent of any alcohol and drug use. But it comes down, I think, the same argument with any mental health case. The level of impairment has to be pretty significant, is what I would say. Okay, remand hearing. Judge says it was a writing war. Asked me, did I still meet the requirements? It was over. Okay. I'm not sure what you mean by writing war, but it sounds like if the judge only spent 10 minutes with you, then that you win. It's really hard for a judge to deny a case when he does not take testimony. So I think you probably won. All clear. I'm not sure what that. I didn't write that, but okay. 7 months, no caseworker. The caseworker is approved. Yeah, well, you're probably talking about a disability specialist or adjudicator. Yeah, that's a lot of time. they have not assigned somebody to your file. And I was looking at a blog, Charles Hall's blog, and he was referring to, discussed a case where one of his employees was trying to get a hold of somebody at Social Security. They hadn't assigned an adjudicator. The case had been just sitting there for 9 months. It's unusual, but it's not unheard of. So, basically nothing's even started on this case for 7 months. This is again where I would call you or email or fill in a form for your elected representative and say, it's ridiculous. They haven't started work on my case. It's been 7 months. Write a letter, and that'll get things moving. Okay. I'm sorry, Dwayne, that you're dealing with that. That's really unfair. Rick says, I was approved for benefits end of 21, backdated to 18. When I was 2018, I'm guessing, when I was 49, a 1-year review, 55 commercial electrician, think a review is coming. If you're 55, no, I don't think so. I think it's unlikely, very, very unlikely. All right, Garrett, my friend Garrett says, it sounds good to me. Well, I'm glad that, Garrett, you are tuning. Hope you're learning something, Garrett. Garrett and I talk a lot, so I'm glad he's tuning in. Donna, visiting SS office tomorrow to fill out another form 561 request for recon. No need to provide updates to documentation. The reason for this second, not sure. Okay, I'm not sure. Oh, okay, Garrett, you're the one who's writing in there. Okay, Garrett works with me in a certain capacity, and so he's been writing things. I'm like, I didn't write that, and I realized Garrett wrote it because he's got access to my Gmail account. Thought I was losing my mind, Garrett, at my advanced age, but I know what's going on. Okay, so the 561, you're going to have to do a disability report along with that, and yeah, I think you want to update the file, absolutely. And there's another form to fill in. In fact, let's just see, request for reconsideration. You're going to fill in a form. 561, and there's another form, and I can't find it right off the top of my head, but there's another disability report form you will have to do along with that. So you want to make sure you look that up or go online to request for reconsideration and request it. Let's see, start disability. I can't find it off the top of my head, but it's 561. There's another form, maybe 5338 or something, where you request a reconsideration. Okay. How long does the appeals council take? In my experience, 8 or 9 months. Could be longer, but 8 or 9 months. Okay, that's Garrett putting that in there. So yes, free case evaluation. If you'd like a case evaluation, please contact me at, I see why you put that in there, the contact 3. Okay, so that is the address to use to ask me for a case evaluation. This tells me it's coming from this live stream, the contact 3. So that's why he put it in there. Okay, makes sense. All right. How is SSDI calculated? High 8. Okay, what Bluegrass State is getting at is there is a calculation for your SSDI that's a reflection of what you've paid into the system, and it's a very complex calculation that I've never done it by hand. Assuming that they've got all your earnings, it's going to be correct, I think. But yes, there is a calculation done. But I would not be the person to ask about how it's done. But, if you wanted to research it, you could figure it out and run the numbers yourself. There's a lot of different, it's a very complicated calculation that they use to figure out the number. It's similar to what they use to figure out your retirement benefit. It's based on the recency of earnings and things like that. It's again, beyond beyond my pay grade, put it that way. MS diagnosis, 39. Yeah, I think even though you're 39, MS diagnosis is pretty significant. So I think you've got a pretty good shot. And you've got MS, major depression, and you can't walk, you can't ambulate steady. I think, and you drop things. Yeah, that's a good case. That's a good case, in my opinion. Hey, Carmen, you got home late. Well, I'm glad you made it. And that's why we run this for a couple of hours. So people that are late can still tune in. I'm glad to see you here. Should I be treating after I won my case? Yeah, you should keep treating. A, because you want to continue to get better and try to get back in the workforce, and B, you should do so because if you should get reviewed, then you will, you'll have a medical record to go with. So yeah, I think that's what you should do. Okay. Let's see here. 54 and 8 months, just not a hearing will be one if it's 55. Better to appeal or refile. Again, if you appeal, you're going to be basically appealing based on your pre-55, medical record. And if the medical record is not compelling and you can't win, and I would run this by an appellate specialist, somebody who does appeals work. But if you reapply and the decision basically said that you meet the grid rule, then you should be approved pretty quickly in a new application. But realize your onset date will be your 55th birthday, basically. So if you're okay with that, then reapply. But I personally would tell you to exhaust, just have someone look at it. Contact, an attorney who does appellate work. Just say, take a look at this. I work with Carl Osterhout or Brian Konoski, are the people that I have review my cases for appeals counsel, and they'll tell you in one way or the other. So email me at ssdanswers123@gmail if you want the contact information for them. Happy to provide it. Carmen says, greetings, everyone. Carmen got here a little bit late, but greetings, Carmen. Why are some people, Ravinia, why are some people denied, others granted, and have the same symptoms, the same ages? Because the people making decisions are human beings. Judges are human beings. And this is something that this has bothered me since I've been doing this. In a hearing office, you may have Judge A who approves 25% of claims. Judge B approves 65%. Whether you win or not depends on which judge you get. That's a lottery. That's not justice, but you're human beings. So just if you happen to get lucky and get a decision maker who is, more open to understanding what you're going through, you're going to win. If you get somebody who believes they have the keys to Fort Knox, they're trying to hold off anybody getting them, then you're going to lose. It's simple as that. It's just not fair. But, I will tell you, statistically, I think the approval rate for 2023 at hearings was about 48 or 49%. So, if you have a judge in the 45 to 55% approval rate, that's kind of on average. Anybody below that is, I think starting to be statistically out of line. Anybody above that, again, to your benefit, would be statistically out of line. I've often wondered whether, an appeals, you could pursue an appeal. In fact, I had somebody contact me about a case where the judge approved 17% of cases, ridiculously low. And I wonder whether you could file an appeal and say that based on statistical analysis, this is so far out of the norm, this is 2 or 3 standard deviations beyond the norm, that this case should be reversed because this is not fair. I don't know if anyone's ever tried that, but that to me would make sense. Because again, how can you be so far beyond the norm and be fair? But to my knowledge, nobody's ever tried that. So maybe one of these days I'll try it. Who knows? Marina, happy birthday! Thank you, Marina. I appreciate it, and I will unfortunately be working tomorrow, but probably take a little bit. I'm going to play tennis tomorrow. Take a little bit off, and maybe leave a little bit early. All right, recon. Is because SS had good cause. What can I do to make okay, 58. Okay, what she's talking about with good cause is that, and this is, Donna had started her comment a few comments ago, but basically, if you miss the 60-day deadline, you can ask Social Security to consider a late filed appeal under good cause. And normally if it's filed within 2 or 3 months even of the deadline, they'll give you good cause. And so, if the medical records, you can only have what you have, but realize recon can take 5, 6, 7, 8 months. So during the time it's in recon, get more records to your adjudicator. So if you don't have them right now, you can get them in a week or two. This is not a fast process. So, again, and as I said before, recon is a, very low approval. And initial, right now, about 36% of initial applications are approved. Recon's about 15%. Hearings about 49%. So getting approved at recon is unusual. It happens, but don't fret. Don't be upset if it doesn't, because it just does not surprising. I need Paula's Donuts the best in Buffalo. I've been to Buffalo once, a number of years ago. I actually tried a case up there back when I flew up there. For a long story, but I actually flew to Buffalo. And then I was in Toronto and Jamestown a couple of years ago in the summertime, just for a vacation. Went to see Lucille Ball's, the Lucille Ball Museum in Jamestown, or Jamestown, I think, New York, up in upstate New York. And we passed by Buffalo. So yeah, it's I've been there one time, but I'm sure Paula's donuts are really, really good. Although again, getting back to donuts, I was one time I was in Oregon. I think was it Portland? In Oregon, and there was a Voodoo Donuts, I think is what it's called. And it was a donut, big old donut, that had all this stuff on there, just nuts and cherries and berries and whipped cream and all that stuff. It was just too much. I think that toppings on, whether it's icing on cake or donuts, simple is better. You don't have to have 5 toppings on a donut to make it good. I think, simple is better. A plain cake donut, or a powdered donut, or a chocolate covered donut, or just even a regular, I forget what it's, a glazed donut. They're fine. You don't need to put all this crap on it. I mean, to me, it's just too much. It's the same thing with pizza, and again, I want to get in a rant here, but, cheese pizza, mushroom pizza, if you like pepperoni or whatever, 1 topping, 2 at most. Don't have 5 toppings on a pizza. It defeats the purpose. Pizza should be 1 topping or no toppings. Enjoy the pizza. You see that guy, Dave, what's his name, who reviews pizzas, Dave Portnoy. What does he always do? He gets a cheese pizza. That's how you tell if a pizza's good. All the toppings, not knowing all these toppings on it. So, same with donuts. Pizza, donuts, keep it simple. That's my opinion. And you can disagree with me, but you'd be wrong. So anyway, cancer-free. I think you were here last week, and I'm glad you're cancer-free. I have an appointment with SS over the phone to do an application. They said they need me a bank account statements where I want the payments to go. Okay, so they typically, when you apply, they will ask, and when I do applications, they will ask for a bank account, so that when you win, they'll have a place for direct deposits. So that's not unusual at all. That's standard practice now, because they really have moved away from paper checks because of all the fraud, identity theft. Much, much better to do it direct deposit. I get my attorney's fees payment in direct deposit. It makes life just a lot easier. So you always want to give them your bank account information. Although make sure it's Social Security. Make sure it's not some scammer. Okay. Donna is the person who filed late but got a good cause, filing for recon. Diabetes, depression, hypertension, perimenopause. I'm not sure what perimenopause is, but it sounds uncomfortable. I'll say that. Severe fatigue, uterine fibroids, cyst, obesity, originally filed in November of 2022, I'm guessing. Again, you don't win on the diagnosis, on the conditions, but the question is, how do these conditions impact you in a work environment? For example, do your female problems cause you to miss days from work? Would you have days, 2 or 3 days of a month where you simply would not be able to be functional? You wouldn't be able to get out of bed, or you might have to leave work early. The diabetes, is it out of control? Do you have problems with neuropathy, with retinopathy, things like that? Does the severe fatigue, do you have to take, as I'm yawning here, fatigue, do you have to take unscheduled breaks during the day? Obesity is no longer considered a disability on its own. It used to be, but it's not anymore. But again, does that impact you in terms of walking, standing, things like that? It might eliminate jobs that require climbing ladders, ropes, and scaffolds, or certain mobility. So look at each of these conditions and ask yourself and your doctor, how does this impact me functioning in a job? I will tell you that, when you have multiple conditions like this, no one is disabling. That again reinforces my statement to you that I think you're not going to get approved at recon. You'll have a much better chance at hearing. And again, what you want to really do is identify the work reliability limitations that arise from each of these conditions. That's what you want to focus on. You are welcome, Emily. Okay. Want proof of age, medical experience, proof of SSI income. Okay, so cancer-free, asked before, they're an appointment with Social Security to do application. They want to have your bank statements. If you're applying for both SSDI and SSI, they will do kind of an initial review to determine whether you exceed the earnings or the income and resources limitations, which are very low for SSI. And it may be that, let's say that you have a spouse who is earning $50,000 a year, or you have a bank account with $75,000 in it. That is going to take you out of the SSI sphere. So they're just going to tell you that we're not going to apply for SSI because you don't qualify for it. That's why they're asking about this stuff. They just don't want to waste their time with taking an SSI application and bogging the system down with an SSI claim when there's no SSI case that's going to be viable there. Okay, I died at November 22. Yeah, again, I think it gets back to one of these specific limitations here. Okay, I let my wife's channel. My wife does workers' comp here in Georgia. Just in Georgia, I do Social Security nationally, but Jody, my wife, does workers' comp in Georgia. And she does it. She's a really good lawyer. I know I'm a little bit biased, but workers' comp is a very, if you've never been through it, I hope you aren't, never go through it. It is a very, very adversarial system. It's more adversarial than divorce. I mean, it is just nasty. You have insurance companies that just don't want to pay people. They want authorized medical treatment to make people suffer. I mean, it's just miserable. And you got to have a real bulldog, a real fighter. And Jody used to work for a defense firm, so she knows all the tricks that they do. And she fights, and she's really, really good. She's a chess player, and you can't have somebody playing checkers when you're doing workers' comp. You got to have a chess player. So she sort of sees things, 3 or 4 steps ahead. She has a vision of where the case needs to land. And, she just really does a good job with her cases, and the settlements she gets are just really, really good. So I realize it's against my wife, and I'm a little bit biased, but I've seen a lot of comp lawyers, in Georgia, which is obviously where I'm here, and she really knows what she's doing. So if you happen to have a workers' comp case or know somebody has a workers' comp case in Georgia, please check out Jody's website, georgia-workers-compensation.com, or just look up Jody Ginsberg, or go to glowlaw, GLOLAW.com, and you can find her there. But thank you, Christina. I thank you for mentioning her work. Just put on oxygen. That was an awful slap in the face. Yeah. No, again, everything you're telling me here is that you're going to win. I don't think there's any question. You're 58. Yeah, I mean, you've got to. I cannot imagine any scenario where they would deny you. I think it's really very, very likely that you'll be approved. I'm sorry. I'm sure you'd much rather be working and healthy than dealing with all this nonsense with all these medical issues and Social Security. Happy upcoming birthday. Well, thank you very much, Donna. I will much appreciated. It is like I said, they come every year and used to get bothered by them, but now it's just it is what it is. It better be on this side of the grass than the other side. And my mom made it to 101, so I figure I got a few more years left. I'm not sure I'll be doing live streams at 95, but you never know. Stay tuned. Dwayne says, it has been 2 years since you had your toes amputated. Why is it taking so long? Well, why were your toes amputated? First of all, there's, Social Security takes a long time because they don't have enough people. 2 years, I acknowledge, is way too long. And this is where I would reach out to your congressperson. But I think beyond that, having 2 toes amputated does not inherently mean you are disabled. I think it would certainly limit jobs where you're having to rely on your feet, standing, walking, climbing, things like that. But what happens if there's a simple sit-down job, you're packing ink pens in a box? Having amputated toes is not going to impact that. So you want to really ask yourself why you would not be reliable at any sort of simple entry-level kind of job. That's one question. Second thing is, why did you have your toes amputated? Was it an accident? Something fell on them? Are you diabetic? Are there circulatory problems that may lead to other questions about your reliability? So two things going on here. Yes, it has taken way, way too long, but more importantly, can you prove that you cannot do anything at all? Having two toes amputated is not necessarily a going to do it unless there's some medical reason why you can't do any kind of work. Happy birthday. Thank you. Okay. Title 16, that is SSI. Basically, there are different types of disability. Title 2, or Roman numeral 2 or Title 2 is SSDI. That is a kind of disability where you've paid into the system and you've got enough credits and you can, you worked enough to be insured for disability, and the payment you get is a function of what you've paid into the system. SSI is Title 16. It is a means tested, essentially it's a welfare program. You don't have enough credits for SSDI, so your payment is not a reflection of what you paid into the system. The statute, the law tells you what you get paid. I think, let me just take a look here. Maximum SSI. Let's try to type this in. SSI 2024. Okay. For an individual, the maximum SSI you can get is $943 a month. And then you have offsets. They call it the deeming rules. And what those offsets do is if you have earnings, if you have money coming into your household, a spouse, that could offset it. If you have certain types of in-kind support, room and board, that could do it. They just changed it. They used to include food as that, but I think they got rid of food. But I think other types of contributions for, let's say, medical care from friends and family, that can also offset your SSI. So many times people who start at $943, pardon me, by the time they finish, it may be $500 because of the offsets. So SSI is a much less robust program. It is much less money typically. And, there's a lot of traps in it because they really haven't changed these income and resource limits for many, many years. I think you can have no more than $2,000 in the bank. You can have a house and a car. But if you have a second car, they look at the value of that car. If you have, a second house or something, or you own interest in property, that can be a problem. So, it's a much less robust program. And many people apply for SSDI and SSI, that they hear, I'm going to apply for SSI thinking that's disability. SSI is a type of disability. The other thing I will tell you is that many times with SSDI has something called a 5-month waiting period. There's no 5-month waiting period in SSI. So if you file a concurrent claim, SSDI and SSI, you could get SSI for the first 5 months. Then SSDI kicks in and offsets the SSI. SSI goes away. So you can have a case with both. It's exceedingly rare that you'd get money from both of them because that means you'd have to have an SSDI payment amount of less than $943. So if you have very, very low earnings, but you've worked regularly and your SSDI was $500 and your SSI is $943, the total you're going to get is $500 from SSDI and $443 from SSI. That could happen. I've seen it happen twice, 3 times in 30 years. Just doesn't really happen. But if you applied for both, that is why they're asking all these questions, and they want to disqualify you from SSI if there's no chance of you getting it, because again, it's an added complication. And I will tell you, because I'm dealing with this right now. I have a client who applied for SSI and SSDI, and I guess they felt like there was enough chance that she could possibly qualify for SSI. Went to a hearing, we won, okay, and she's waiting for a check. The problem is that SSI has to do this income and resource interview. I don't think she's going to qualify, but they're backlogged. So the SSDI part has been already processed, but we got to wait until they do the SSI part. So she's going to wait another 2 or 3 months, very probably, because they got to do the SSI calculation. If I had been her attorney at the beginning, I would have said, don't bother with SSI because you're not going to get it because you have too much in terms of resources. But, she didn't know. And so now it's just causing a huge delay. Okay. Terry Clemens. I was denied by the ALJ. I had 3 doctor's reports Didn't give one of my doctors RFC or heart attack, diabetes, foot pain. What should I do next? Terry, I don't know how old you are. That's one thing. I think that if you're within the 60 days of the denial, I would have somebody look at it to see if there's grounds for appeal. If there are not, you could reapply, but realize when you reapply, you've got to show something has changed, something significant has changed. So if you got denied on Tuesday and you reapply on Wednesday, but nothing has changed, you're going to get the same result. Usually what I look for would be you went from 49 to 50, or went from 54 to 55. Something has changed, or you have a new medical problem. But if it's all the same and your age category isn't changed, you're probably not going to win. But again, I would exhaust the appeal question first. And if you're really finding that you are not going to win an appeal, or you've already passed the 60 days and you reapply, the question to ask yourself, what has changed? Is it significant enough? The truth is amazing, and the truth is amazing. I had a remand hearing July 3rd. I think you said, the judge says, why are we here? 87% approval rate. Ask the ME. There's a medical expert there. 3 questions, no questions to the VE. That's a good thing. I had a video I did about a couple of years ago saying why I love 5-minute disability hearings, or why I love hearings where I don't have to say anything, because the case is so clear, and the judge is like, why are we here? And I love those cases. If I don't have to speak, that's a good thing. One thing I learned long time ago in bankruptcy court. This is going back many years, and I was watching in a bankruptcy. I had a case come up before a bankruptcy judge. There was an attorney who was arguing. I'm not sure who he was arguing for, a mortgage company or for a person who's filing bankruptcy. And the judge says, "Okay, I'm going to grant your motion." And the guy kept talking, and he kept talking. And 10 minutes later, the judge is like, you know what? You talked yourself out of it. I'm going to deny your motion. And I'm not sure if the judge was just being a smart aleck, or the person really said things he shouldn't have said. I don't remember. But the point is that if you have nothing important to say, don't say anything. And I think, lawyers, tend to talk a lot. But I've always been of the belief, I used to tell my kids this when we were younger, God gave us 2 ears, 1 mouth, which means we use them in that proportion. So, there's no reason to talk if you have nothing to say. And if you've got a judge who's going to approve you, the judge will say, Mr. Ginsberg, do you have any questions of the vocational witness or the medical expert? Nope. If I know I'm winning, I'll say nothing. So, that's a good thing. That's a good thing. Obviously, the real question here is they put you through, a long time of waiting, when this case should have obviously been approved a long time ago. But what are you going to do? But congratulations. Very confusing, like David and Goliath. I think what Carmen's getting at is that Social Security can be confusing. It can be unfair, and the whole SSI and SSDI. Look, I sort of see it. I used to describe it to people as its own separate universe. You got all these acronyms: AOD, alleged onset date; DLI, date last insured; SGA, substantial gainful activity; TWP, trial work period; RFC, residual functional capacity; MSS, medical source statement. I could go on and on and on. And yeah, it is a separate universe. It has got a separate vocabulary. And, part of the reason why there are attorneys like me that do this is because it is so ridiculously confusing. A general concept shouldn't be, but it is, that you almost have to have legal representation to have a chance. You go to a hearing and the judge says, what's your theory of your case? And you don't know what he's talking about. Is it a functional capacity theory? Is it a grid rule theory? Is it a listing theory? You don't know where, go through the 5-step sequential evaluation process. What? Well, that's just what it is. I mean, that's what they call it. So they've taken a general concept, and that is, do you have a medical problem that prevents you from working? They've added all this layer upon layer of sophistication and confusion on it, where it makes it really hard for a person to do it on his or her own, and that's too bad. Again, this is what I do for a living, and this is just the way governments work, but it's really, big picture, it's too bad that you've got to pay a lawyer to do something that really you shouldn't need a lawyer to do, but you just do. I wrote a book a number of years ago about all the disability forms. It's at disabilityforms.com. And it's basically how to fill out the forms. And I'm actually right now revising it to make it an online video-centric kind of course. But it's still in book format. I got a couple of copies left. But the point about it is I went through all the forms, and I went through and said, this is how you answer the form to improve your chances at an approval. This is what you want to say, and give examples and sample examples of all the forms. And I've been selling this book for 10 years or more than that, really. And every so often I have to redo it because the form changes. And what happens every single time is the form goes from being a 3-page form to a 5-page form. 5-page form to a 7-page form. It's almost like, and I was joking with somebody last week, there's some little guy, in a suit that's too small, sitting in an office someplace, in Bethesda, Maryland, whose whole job is to create more confusion with all these forms. I am convinced of that. It is just insane. And they just keep making it more and more difficult. Look, the form that we fill in, it's called the 1696, that when I'm an appointment of representative form. And this is a form that I have to submit every time I apply, represent somebody. Used to be 1 page. It is now, I think, 9 pages. No reason, just it went from 1 page to 9 pages. And it's just, they ask all this stuff that they ask elsewhere. They don't need to know, but they ask. They've given me I have a rep ID number that I've got to, put on all the papers so they know who I am as opposed to my name. They're going away, by the way, they're eliminating social security numbers as a way to identify you. They're using something called the B&C number. I don't know what B&C stands for, but the B&C number, and it changes all the time. It's beyond insane the way they do it, but this is the way governments do. So yeah, David and Goliath is probably a pretty good thing here. Okay, so Garrett has put this in again. If you or a loved one would like a free case evaluation, please contact me at this address, bit.ly.com, contact Jonathan3. This will tell me that this is coming from the live stream. So that's helpful to me to know, the reach of this live stream. So yes, if you do wish to have a free case evaluation, let me see if I can copy that into the screen crawl. I don't know if I can or not, but I don't think I can here. But anyway, that's how you can get a case evaluation if you'd like. Ravinia says, I appreciate your help and happy birthday. Thank you very much, Ravinia. I appreciate that very much. Emily says, I want a job with SSA if they're short-staffed. Apply. I mean, they are. Now, I will tell you that SSA is not considered to be the most fun place to work. There is a federal survey that's been done for many years. It's done every year, and SSI is the bottom of the list. So it's not a pleasant place to work, but a job's a job. So go ahead and apply. And certainly if you have a disability, they will take that into account, and maybe you can get there. And if you do, let me know. So I'll have a contact on the inside. I can call Emily, and she can maybe cut through some red tape for me. So if you do get a job with them, please let me know. But it is it's challenging because you're given a lot of work and not enough time to do it in. But to go for it. Glenn just got approved. Meet a listing. Okay, just got approved. You sure not SSDI, SSI, which is Title 16. Got my back pay yesterday. So if it came all at once, it was SSDI. You met a listing. But yeah, I appreciate that. I mean, I think, this is an area where it's actually kind of interesting. I'll tell you, I've done this for a long time. And what I find is that it's really interesting to learn about a lot of different medical problems. You obviously want to be aware of what's going on if the benefits get cut because the budgets, the Congress doesn't refund Social Security or continue disability reviews. But I appreciate you tuning in. And, in fact, if you want to email me, Glenn, and let me know about your experience, that's always helpful to know because everybody's SSD answers 123 at Gmail. It's always interesting to know about people's experience with Social Security. So, yeah, I'd be interested to know how it went for you because maybe you had a good experience. I hope you did. Carmen says, you're thankful. I'm happy to share what I know. I really am. The truth is amazing. The ALJ says he doesn't let me second guess for the AC. It's a writing. Okay. So I think what's going on here is that the truth is that like the situation from Jersey Shore? The truth is amazing. That's a reference. I don't know if how many of you are going to get that, but the Jersey Shore was back a number of years ago. My kids used to watch it. I thought it was a ridiculous show, but they had a guy called The Situation. So anyway, but the truth is amazing. What he's getting at is that he appealed it to the appeals council. The appeals council sent it back and said, Judge, you didn't do your job properly. And so the judge is hopefully going to approve it. And I asked this question of my friend Greg last week, because I've had this happen a few times. Some ALJs, or administrative law judges, they get reversed, called remanded. It goes back to the ALJ after the appeals council, and the ALJ, the appeals council says, you didn't do a good job, Judge. I'd say majority of the time, 75% of the time, the judge is going to go ahead and approve it because he just doesn't want to deal with, the appeals council and all that stuff. There's some judges who just, get their hackles up and they're like, I don't care what you did, appeals council, I'm going to deny this case, and I'm going to show you who's boss. And obviously you want a judge to do their job properly, and obviously if the appeals council reversed it, there was a reason. I had one case, I talked about this last week, where the judge, I think the judge, my friend Rodney here had, I got it reversed on the appeals council, comes back and he grants the case, but he writes, actually this went to federal court, he writes a page and a half footnote to the first page of his decision saying he doesn't believe anything the claimant said, but he's only going to approve it because the district court says he has to. Just, unnecessary to do that, but he did it anyway. But he approved the case, which is good. But, that's some judges just feel like, that the appeals council is stepping on their turf. Other judges are like, okay, it's just the cost. This is business. Business is business. And some judges just feel like, okay, I don't want to, I don't want to mess with the appeals council. There's Rodney again saying, congratulations to Glenn. Congratulations for me as well. Let's see here. Okay. Good question, Trish. In your husband's electronic records, a worksheet, keep that in mind, shows his limitations were light work and he is high school grad unskilled. Will that opinion remain valid until he turns 55 and grid 202.04 apply? Probably. Now, the worksheet is probably done by somebody at the state agency. And I think you could make the argument that the state agency found that he was limited to light work and an unskilled, RFC, functional capacity, as a high school grad. The problem is that at a hearing, the judge is looking at this as a de novo, a completely new review. So it's not going to be binding on the judge. Now, most judges, in my experience, if they see the state agency found this particular RFC, limited to light work and unskilled, they will go ahead and grant on the grid. Or the state agency, now that you're turning 55, the state agency would be bound by its own prior determinations. So I think that, there's probably an argument why they wouldn't have to be bound, but I think reasonably speaking, as a 55 in March of 50, when he turns 55 in March of 25, then he should be fine. But that doesn't mean you can't try to get him approved at 54 or 53, because, maybe he can't, even though he could theoretically do certain things, he wouldn't be reliable because of severe pain or something else. So don't necessarily just accept, you're going to have to wait until he's 55. Maybe he can get approved earlier than that. All right, Glenn and Rodney, thank you. Okay. Blue MD says, thank you. You're very welcome. Emily's the one who said she's going to go look for a job with Social Security, and I hope you get it. So good luck. I agree. Okay, Loki and Pearl. Loki and Pearl. They have what does this say? Like a avatar here. That's pretty cool. It looks like Loki and Pearl are two dogs because they are dog faces. And as you all know, I'm a dog lover. I have my dog Sadie, who's a 75-pound golden doodle. I've had her here a couple of times, but she tends to get kind of needy, so I didn't let her come in today. And then my son has a 50-pound. My son's an adult. He's 31 years old, but he has a golden doodle named Ella, who is, Ella and Sadie are kind of like good friends. And then my daughter and her husband have a dog named Stanley, who's a golden doodle, who's not very well behaved. And then Stanley, Ella, and Sadie will come over to our house, when everybody's coming over, and they just have this, they just wrestle, and they play fight, and they're growling and barking and wrestling, and it is just nuts. And almost to the point where it's just like, I got a 10-month-old grandbaby, and sometimes it gets to the point where like it's a little scary for her because she's just watching. She laughs for a while, but then they start growling, and it kind of bothers her a little bit. So I really like dogs, but big dogs obviously can be, they're usually real friendly, or at least golden doodles are, but they can be kind of wild. But Loki and Pearl look like they're smaller dogs, maybe dachshunds, if I can't tell, but I like dachshunds if they are. But nice avatar there. The most back pay you can get is 12 months. No, you can get 12 months back from the date you applied. But if, again, let's say that you applied in 2023, in January of 23, alleging an onset date in January of 22, and you're approved in 25. So you're going to get past due benefits from, factor the 5-month waiting period in, from, let's say, July of 22 through January of 25 or whatever. So you might have 3 or 4 years of past due benefits. You can only get 12 months from the date of application, but if your whole case is running 3 years, when you add in all that extra time, then you can get 3 or 4 years of past due benefits. And if you appeal it, the appeals council gets sent back, you could be 5 years of past due benefits. So no, you're not limited to 12 months. It's 12 months from the date of application. You can go back and get paid 12 months from the date of application. But your onset date, the other things are going to have more effect on it. Carrie Berry. Is that your real name, Carrie Berry? Anyway, Carrie, I'm guessing Carrie is your name. Carrie is over 55, but an SSDI, but been better. I was better for about 7 years, and my vision depression got worse. Does it bode well for me that okay, so I'm guessing that Carrie was on SSDI, then left it because it went back to work or medical improvement. Now she is reapplying because of vision and depression. Does it bode well? I happen to think so, in the sense that you went back to work, presumably, and Social Security always appreciates people that go back to work, or that tried to get off of disability. So the fact that you were off of it and you have to go back on, I think that it probably does benefit you to some degree. It's not binding on them, but it does, I think, help a little bit. So let's see here. I lost my spot here. Well, okay. Well, anyway, I'm losing my. I'll put this back on while I'm trying to find myself here. Okay, Nomad says this is a replay. No, this is a live stream. July 10th, 2024. All right, so I'm getting close. I got 15 minutes to go, so let me kind of zoom through. Nanika says, a few weeks ago I said, get a congressional inquiry. This was a response we received. Case currently assigned our courtesy unit, processing time of very file set on somebody's desk. Some congressional inquiries are a little more persuasive than others. I happen to think U.S. senators are going to be better than a representative. That's just personally. But if you didn't get help with one, try somebody else. That's, to me, not a very not all that. Oh, here's Carrie Berry. Okay, that is not, to me, all that impressive of a response. I think they need to do more than that. Google review. Yes, I prefer Google reviews because Google is the 800-pound gorilla in this space. I think I've got a link to Avo. You can go to jonathanginsberg.com and you can see Avo and Yelp and all that stuff, but Google is the big one. Hope you have a good birthday tomorrow. I hope so too. The dude, thank you for what you do. Happy 25th. Okay, I like that. Okay, awesome. How does my mom apply? I don't know. I really don't know. That may be more of a state issue, or I forget what they call it, a guardianship issue. I don't know if that's a Social Security issue. EM, happy birthday. Thank you. Guess I'm safe at 64. Yes, that is correct. How to approach a case with mental health issues, suicide attempts, but also drug use. Drug use is caused. Yeah, I mean, if they find that drug use is a material contributing factor of your disability, they can deny you. It's hard to unwind those things. You really need to have a treating psychiatrist really try to unwind it for you. It's very hard, very, very hard to do that because they are going to try to, somebody says stop doing drugs. Again, and I know that's kind of flippant, Marie, but I'll say this, that, sometimes if somebody has an underlying mental health condition, it can be really hard to have the self-control to not self-medicate. So, and drugs can be very, very addictive. I mean, it is a disease. And I've had a number of clients who are good people who have addiction problems. And look, my son, I mentioned he's 31, and, there are 5 people he grew up with who died of drug overdoses. Good families. I knew these kids. And it can happen. It's just, it's that stuff gets in you, and it is just, if you have that gene, addictive gene, it's game over. It can be really, really difficult to wean yourself off it when you have an underlying medical problem, a mental health problem especially. Dude is in Vegas. It is hot. The dude is hot. 110 in Sacramento. It's hot. Why would they send you to a CE for a CDR? Yes, CE exam, because they want to know what's going on. They think there's been medical improvement. They want to find out. That's why they're doing it. And then they decided for some reason they canceled the CE and said, okay, no harm, no foul. Well, that's good, but I'm sure it put a lot of stress on you, but that's what they do sometimes. Thank you. You're welcome. Jerry, I think, is a truck driver, a tow truck driver, in Reconsideration. If I fill out invoices, ask for hire employees. Okay, ask if I filled out invoices. They want to see if you're doing any work, is what they're doing. So, you may not be driving a tow truck, but you may be doing billing. And a billing clerk is a job. So if you're doing work, for a decent part of the day and you're generating earnings, or you're doing activity that should be generating earnings, that could be grounds to turn you down. Because billing clerk is a job. Now, if you're doing it one day every 2 weeks, I don't think there's a problem. If you're doing it, every 3 days, more of a problem. You're doing it every day, that's a problem because it looks like work. But thank you for the birthday. Now, those cakes look pretty good. Rick says, and we got 10 minutes to go, can unearned income become an issue if they see a lot of money? It can, but you may have to just explain that this is unearned income. Usually not a problem. But you have to explain. Emily says, at what point can you relax a little bit? I know, Emily, from previous comments that I know you're struggling with some mental health issues, so I can't tell you when you can relax because I don't think you probably won't. I think the older you get, and that's going to help. And of course, the more significant the medical problem or mental health problem is, that's going to help as well. Not a weird comment, but yeah, I get it. Garrett says, a cerebral tennis player. Yep. And Garrett, if you ever get down to Atlanta, we'll see who can win. Okay. Let's see. Garrett, you've been here a lot. Okay. And Garrett's making sure that I put this in here every single time, and I will put it on the crawl next time. Or something else. So Garrett will be out, and I'll be on my case here. Okay. Annie Davis. Okay. You met a listing, you proved, hey, that's awesome. Thank you, Annie. That's great. I'm glad that, whatever little part I was able to play by giving you information, I'm very, very, very happy for you. And it sounds like it was well deserved. Yeah. I will hopefully, well, like I said, on Saturday night, I'm going out to the Capitol Grill, so I will be with family, not so much friends. Hopefully the friends will show up with a cake on Sunday or something. Applied for disability after my 6 months of unemployment on set date. We weren't able to, yeah, I think my opinion, the underlying question here is, if you apply for unemployment, is that inconsistent with applying for Social Security disability? My opinion, no. You're not a doctor. You're saying I'm ready, willing, and able to try to work. Doesn't mean you can work. So I think it's not, and I've not had in the last 15 years a judge tell somebody they're not eligible for disability because they applied for unemployment, especially given the long delays. They're not going to tell you you can have no money coming in and you're waiting for 2 years and then, oh, by the way, you got unemployment. That's a problem. So I don't think it's a problem. I think you can apply on day one. I agree with Rodney if you're over 55. Well, she's 53. So even over 50, I think you're okay. Yeah, they just, again, I think we've already talked about that. Let's see. So that one, I'll put this up again while I'm scrolling here. Okay. And Calvin says, my nurse practitioner is filling up my RFC form. Will it help your case? Yes, a nurse practitioner is considered an acceptable medical support, for a medical treating source. So yes, that's fine. Happy early birthday. We're getting pretty close, Madeline. Hey, Madeline. Madeline works for me. And yes, happy birthday. Thank you very much. I'm sure, hopefully your coworkers will, I know they'll remember because you're going to remind them. Madeline's the friendly voice on the phone who does a lot of call screening for me. So, hey, I got approved for disability fully favorable in April. Why is it taking so long to make my lump sum? Did you apply for SSI and SSDI? That could be the problem. Otherwise, it just could be a holdup on the Social Security's end. But I'm guessing SSI. I've just finished the medical and psychiatric exam. How much longer should I get an answer? No telling. Could be 3, 5, 6 months. Who knows? There's just no there's no set rule on that. Can SSI, Social Security, approve your claim without getting a lawyer's mental health, physical health, hygiene? Again, yes, they can approve it without getting a lawyer, and we've had several people comment that they did it without a lawyer. More power to you. Again, you've got a lot of free resources. The my websites, my videos, live stream, and is mental health and physical health hygiene? It depends on the severity of it. It's like saying is 10 pounds a lot of weight? Well, if you're 2 years old, that's a lot of weight. If you're a bodybuilder who's 45 years old, it's not a lot of weight. It just depends. That's a silly example, but first one that came to mind. Got a lot of happy birthdays here. Okay. All right. We're getting close to the end, so I'll take a couple more of these. Okay. So T-Cash says, I got a letter from SSA saying you meet the medical requirements, but the non-medical requirements and what those are. And Greg talked about it last week. In an SSDI case, they want to make sure you're not working and that don't have earnings over SGA. And if it's SSI, you're not over the earnings and resource limit. The Chevron case, somebody asked about this last week. The Chevron case basically overruled the Supreme Court case that it's not the Chevron doctrine was passed by the Supreme Court or enacted a number of years ago. There's another case that came along that overruled it. I don't remember the name of the case. It overruled Chevron. So what it says is that that administrative agencies don't have the power to do what they've been doing in terms of rulemaking. That is limited to Congress. So, in theory, it could force Congress to come back in and sort of redo everything that SSA as an agency has done. Will it cause things to run amok? Probably not. They'll have a workaround, but it does limit the scope of what agencies can do. It's kind of an obscure, it's a very important concept, but it's kind of hard for me to explain it in 2 minutes. But if you look it up, you'll see Chevron has been overruled by this other case, and there's a lot of commentary out there what that means. But it probably will not change things too much on a day-to-day basis, because what Congress will do is they'll just kind of absorb all the stuff that SSA has been doing over the years and bless it. And now all of a sudden it's legal again. Yes, should you have your attorney call? It's been 13 months. Yeah, I would. Okay, we're getting down to a couple minutes left. So Okay. Yeah, I'm not sure why that happened, Nomad. This is live. Okay, I understand when you are, so you get a part, you can, but just keep your, I talked about this a little bit earlier, but keep your earnings below 1550 or SGA. If you can at all do so, that would help. Obesity is not a disability, it can have reasons. Yes, that is exactly right. Sandy, I'm in South Carolina. Let's see, I've been waiting a decision for denial approval next month, 15 months. Workers' comp, yeah, you got to wait for workers' comp to send in the documents. That's exactly right. Let's see here. Now that work history 5 years, who benefits? The claimants benefit. If you are, now that's 5-year work history, they can't go back and say you did something 15 years ago that's applicable and relevant now. I know I'm right on about pizza and donuts. I am. Keep it simple. That's it. Okay. Let's see. I have a question with different SSD, SSDI, and SSA. Okay. I think you mean SSI. Go to my website. Go to 4socialsecuritydisability.com. The number 4 socialsecuritydisability.com. I explain the difference in SSD and SSI. SSA, by the way, is Social Security Administration. SSDI is disability insurance. But just go to 4socialsecuritydisability.com and the FAQ. You'll see it there. Thank you. Thanks, Christina. I'll go to a steakhouse and have fish. I will absolutely do that. All right, last couple of questions. Can you speak? Mark Tedson says, can you speak to why it's important to keep updating your medical appointments after a date last insured? Because you want to show, you're painting a picture when you file a disability case. And so you want to show that you have an ongoing problem that remains a problem and that your disability did not end. It's not a closed period. It didn't end as of your date last insured. It continues on. Now, obviously, they're going to be more concerned about what was going on before your date last insured. But if after your date last insured, things change dramatically, you might have a judge saying, well, wait a minute, that doesn't make any sense. Why was he disabled before then, now not now? Or why is this case should be ongoing disability as opposed to a closed period? So I think it's just, and for your own benefit, you want to get better. You want to get better. Okay. Okay. Blah, 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 blah. Let's see. Okay. So I think we are now at 2 hours. So I'm going to need to, okay, Emily, we'll leave it at this. Emily is correct. Answer the judge's question briefly and stop talking. Yes. You know, again, people want to sometimes talk and answer questions that are not asked, but please stop talking. Yes. Abdul is 53 with neck and back problems, insomnia, anxiety. Again, it's not the definition. It's really about how severe it is. He's got knee issues and a torn meniscus. How severe it is. How severe. That's really the thing here. Okay. And so we'll leave this here because I've got to go. At my age, I got to get my beauty sleep. And somebody says I'll be watching my podcasts and live streams when I'm 90. I hope I'm doing them when I'm 90. You know, my mom was really in pretty good shape at 90. So, you know, she could have done them. She developed some dementia after that, but up till about 92, she was in really pretty good shape. So I'm hoping I got those genes. So we'll see. So anyway, I really appreciate everybody being here tonight. And I will see you all hopefully next week. I'm working on some guests and hope to have that firmed up. I think it's kind of fun to bounce things off other people, and especially people who have worked for Social Security. So, you know, again, as you see in this last comment, if you like a case evaluation, you can please just contact me at ssdanswers.com. And again, if you found this live stream useful, please give me a nice review. It really, really helps. So again, I'm going to go now, but I really appreciate everybody's tuning in. And we will see you, hopefully I should see you all next week. So that's it. Take care. Bye-bye.